So you cannot talk about anything else other than this act only applies to this. So this is the application. So you can clarify it and make it better English and repeat it and say, as stated in, as per the application of the law. But you see, this act applies to a person who is an agent of a foreigner. This act. So don't ask me, who has no dealings with a foreigner, under this act. I have no business. Exactly. It does not relate to my grandmother in the village, who has no dealings with a foreigner. You cannot come. So your grandmother can solicit with from a foreigner. My grandmother can solicit from a foreigner so long as they are not doing activities under 2.2.
Okay. I think it's. Thank you.
No, the minister's powers, because you see, if you say that you should allow people to receive $1 billion, I don't know. I'm looking for words to use in English, but I can't find them. But I may be more expressive in Uganda. In Uganda, we're saying you know, you're saying that you may try to cover yourself. Okay, having spent the whole night uncovered, at about 6 in the morning you cover yourself. You have not served any useful purpose. So if you allow all the money to be spent, and then the problem has already been done.
Attorney General,
so reporting tomorrow.
The current practice is, even when I'm receiving people, you do not restrict, because first of all, at the level of soliciting,
but I've answered the question, Honorable Segona. I've told you my understanding of it. Okay. You have said you'd rather let the amount and they report then after.
Actually,
so we are saying, if they are receiving money for purpose of recruiting a rebel outfit,
then they declare after.
Then they declare after the rebel outfit has been recruited. Well,
fait accompli.
So we are saying that the declaration after may,
No. Actually, contrary to what you think, and by the way, I should be understood being the Anti-Money Laundering Act, which requires the banks, before they even allow this money onto my account, I'm required to explain
declare
and
source.
Even prove, declare the source. And someone has been bounced back, which I also find outrageous. If it has come, why do we bounce it back? Let the government take the money. But my question is, one, delaying transactions. Two, is where the minister does not even have timelines.
That is now a function of law.
We can further bureaucratization of what we want to achieve. There is the aspect of the checks before the fact, which the Attorney General alluded to, and not after, when things have gone bad. But also the bigger worry of the committee was, what if the minister abuses his power? So what better way, if not the minister? I think that we should leave to the committee. If you think the minister is overweight with this responsibility, which is going to be frequent.
Thank you. Mr. Chairman, I would like to inform Honorable Uweri. As I stated earlier, this law is targeting very few individuals. And looking at the other paper now, you clarified.
Yes.
It means by this week or next week, the law will be passed. Aware that one of the opposition leaders now is out of the country, and government assumes that the opposition leaders who is out of the country may come back immediately, and he may lobby huge amount of money. And what the government is fighting for, by the time Bobby Wine arrives to Uganda, the law should be in place. So you are targeting very few individuals, which is very wrong.
Honorable Anya, dashing in, let him take seat, and then the introduction on the visitors' side starts. Okay, over to you. AG, introductions.
Good morning, Honorable Chair and members, Chiriwa Chonka, Attorney General. Honorable Chairs and colleagues, I have shared with you a presentation that I have prepared for the committee. I am not going to read, if so pleases you, Mr. Chair. I'm going to highlight the areas in this statement and try to speak to it and try to break it down as best as I could. So, honourable colleagues, the background to this bill has been well set out by the Honourable Minister of Internal Affairs and is really to deal with the management of our sovereignty. Honourable colleagues and honourable members, this is based out of our Objective 4 of the National Objectives and Directive Principles of State Policy, which require that the state and the citizens shall endeavour to build national strength in political, economic and social spheres to avoid undue dependence on other countries and institutions. Honourable colleagues, Article 1 of the Constitution reaffirms the sovereignty of the people of Uganda, and the sovereignty of the people of Uganda is to ensure that nothing threatens the nation's ability to self-govern without undue external influence. Colleagues, in the absence of the law to protect the nation's ability to self-govern, there has been increase in the interference in our development and implementation of our government policies. Of course, I must emphasize that under our legal and constitutional framework, the policy of government is determined by the government in power at the time, the ruling government at the time. Every citizen has a right to participate in the formulation of that policy, but they are not the policy holders. They share, and then the policy is determined by the government. So this is done through the representatives that we elect, all the way from LC1 all the way to the top. That is how policy is formulated. Otherwise, you can find a situation where each one of us, 41 million Ugandans, may have an idea on how a particular matter, for example, some of us may think that we should drive on the right-hand side, and others think we should drive on the left-hand side. Imagine a country where every citizen decides to engage in their own policy. That would be chaos. So that is brought together by the government now, coming together and engaging with the citizens and coming up with a common policy on that issue. I'm using a simplified, a simplistic example, but it's just to try and drive home why it's extremely important for someone to be responsible for a policy of government. So, honourable colleagues, like the Honourable Minister of Internal Affairs stated, we have several laws that have looked to try and address this issue. But we do not have any particular legislation which has boldly and openly come out to address the issue of protection of sovereignty. And that is what this law is looking to do. Honourable colleagues, Annexure 1 to my brief has got the list of jurisdictions and pieces of legislation that we have consulted. This is not new to Uganda. We have there 17, but if you go out there, you'll find as many as the countries exist on how they deal with the issue of protection of their sovereignty. The issue is, how do we want to do it, and why should we do it that way? And like the Honourable Minister of Internal Affairs said, we need to make a law which works for Uganda. Honourable colleagues, at page 4, I address the justification of the bill, and the justification of the bill is clearly set out in the objectives of the bill. It is to fill the policy gaps, to cover the areas that are not covered by the law, to preserve national security and social stability, to uphold self-determination in policy making, strengthen governance and accountability, and of course protecting the cultural integrity and social values of the people of Uganda. Honourable colleagues, honourable chairs and colleagues, now I go to page 5 and address the scope of the bill, and I want to spend some time on this area because I think this is where our legal part comes in. Honourable chairpersons and members of the Protection for Sovereignty Bill seeks to enact a law that intends to provide the protection of the sovereignty of the people of Uganda by regulating agents of foreigners and funding from foreigners that is intended to influence government policy. Maybe just to emphasize here, everyone will look to influence government policy, and every Ugandan has a right to participate in any process to influence government policy. But if you're influencing government policy in the interest of a foreign player, that is what this law is dealing with. So if you come here to Parliament and you want a policy to be addressed, you want an issue to be looked at, that's perfectly fine. But if you come to Parliament, even as a citizen of Uganda, for purposes of influencing the policy for the benefit of a foreigner, then that's not good. And that's not acceptable. And that's what this bill is looking to protect. In particular, Clause 2 of the bill stipulates the specific areas that the bill will apply to. And I think this is what we need to really address our minds to. Because I have heard people talking about people carrying on their legitimate business being affected by the sovereignty bill, people sending money to their parents or parents and children and etc. being affected by the sovereignty bill. That's not the scope of this bill. And I'll go through these items one by one. The scope of the bill deals with engaging in political activities of Uganda for and in the interest of a foreigner. So if you're dealing with political activities in Uganda for the interest of Ugandan, that cannot be the scope of this bill. But it's for interest of the foreigner, that's the scope of this bill. Soliciting, collecting, disbursing or dispensing contribution, loans, money or other things of value for or in the interest of a foreigner. Representing the interest of a foreigner before any agency or official of government, of the government of Uganda. For example, you may come here and say, we should not be, I have a foreign entity which I'm representing here, and its view is that the foreigners who are dealing in business in Uganda should not be required to pay tax. That's perfectly fine. But when you come to government, to the government official, come and tell us you're an agent of a foreigner and you represent the interest of a foreigner, so we listen to you as such. That's what the law is saying. The law is saying you cannot, it is not stopping you from representing the interest of a foreigner, because there may be Ugandans who have interests of foreigners here. We are saying just lawfully do it. Register and say, I am an agent of a foreigner and this is my interest. And not to say that every foreign policy is bad. But if you bring it to Uganda, bring it clearly, stating what your interest is in that policy. Agreeing, consenting, or assuming, or purporting to act as, or who is, or holds himself or herself out to promote the interests of a foreigner against the interests of Uganda. We have our cultural values. If you want to go and promote a foreign value, it's perfectly fine. Just register as a foreigner and an agent of a foreigner and represent that interest. Influencing the development policy of Uganda. For example, in Uganda here, we may say that our development policy now is putting money in the hands of the people through PDM. But you may have a different view. And maybe there is a foreigner out there who does not think it is good for government to give direct grants to the people of Uganda. Because when you give grants to the people of Uganda, maybe they want to borrow money from the bank and etc. And therefore it is your interest to come and promote. So that is the policy of government. The policy of government is under PDM. But if you're coming here to influence that policy negatively or otherwise as for the interest of the foreigner, then that law prohibits that. Funding political parties, organizations, or other persons contesting for election. If you're a foreigner, you have an agent of a foreigner, you want to install into government a government. So you decide to form a political party, you get funding from outside for purposes of protecting the interests of foreigners by, for example, saying, after we have come, we shall amend the law and give all these other people from this country citizenship in Uganda. That's wrong. So you become an agent of those people. And that's what the law is saying. The law is saying just register, come and do it, and feel free to act accordingly. So the scope of the act, as stipulated in Clause 2, is exactly how far it goes. It will not apply to funds received by private persons, commercial entities, for family purposes. If I'm receiving money from a foreigner for purposes of doing my business, that has nothing to do with the scope in Clause 2. So that cannot be foreign that cannot be, you cannot become an agent of a foreigner for that. So it can only be in that scope. So the Act will only apply to funds that are meant to fund the activities listed in Clause 2. That is the activities that are intended to promote the interests of foreigners, influencing the development policy of Uganda, and funding of political activities or contesting for elections for the benefit of foreigners. Of course, the question has been out there. How do we know? That's a question of evidence. For example, when we wrote the law that it shall be criminal to commit murder, we did not tell you how to prove murder. If you stab by the knife, we go and get the evidence, the DNA, in order to prove that you committed that offense. So even if a person received funding from a foreigner and it is meant for these purposes, it is incumbent upon government, if they intend to prosecute that person under this law, to get the evidence to confirm that that person actually brought those funds for that purpose. And if they cannot, then the law will not be held against that person. Honorable Chair and members, concerns have been raised regarding some of the definitions in the bill. It is important to note that the definitions provided for under the bill are only limited to the context of the bill. The word foreigner, for instance, in the bill is used in reference to a foreigner who engages in activities as set out in Clause 2 of the bill. That is activities that are intended to promote the interests of foreigners. So further, the inclusion of Ugandan citizens residing outside Uganda in the definition of a foreigner is only limited to instances of where a Ugandan citizen residing outside Uganda is engaged in activities under Clause 2 of the bill, and that does not affect their citizenship. Honorable colleagues, maybe just to emphasize this, because it has been a matter of grave concern in the public domain. Of course, the committee will look at it, and we will all look at it, and if there is clarity that needs to be made, we make the clarification. We are saying, for example, if a Ugandan citizen has $100,000 and is in America or in Sweden or in another country outside Uganda, and he decides to spend that money to support his local MP in an election, that's not an action of a foreigner. That's him acting for himself. But if that Ugandan had $100,000 and in concert with foreigners said, let us install a particular MPX for purposes of doing this activity, that person becomes an agent of a foreigner. So even you in Uganda here, if you're in Uganda here and you get money to support an MP, but you get that money for purposes of supporting the interests of a foreigner, you become an agent of a foreigner. So this has nothing to do with citizenship. It has everything to do with the action that you're doing, the purpose for which you're doing that action. And I'm sure the committee will look at it, and if need be, we can correct, clarify, amend, whatever it is, so long as the purpose is not lost. The purpose is, it is not to take away the citizenship of that person, but it is to tell all of us, do not act for the interest of a foreigner. But every Ugandan should be at liberty to participate in the affairs of this country as long as they are acting for their own interest as Ugandans.
Mr. Chairman, with your permission, maybe I do not want to join Honorable Gilbert Olanya in thanking the Attorney General for the courage. At another occasion, I will know how to deal with him. One, Mr. Chairman, if you look at the definition of a foreigner does not mean, but it includes. In my little memory of legislative drafting, when somebody says includes, the definition is so wide that it can incorporate and keep bringing in anybody, and that it will depend on who chooses to enforce the law to bring you into that bracket, as long as they use the word includes. So I wish the draftsman would be clearer to say it means the following people. I have already opined that probably you need to, even when it is ugly, Honorable Chirewa Chwanuka, you can court it by removing the use of that word foreigner and criminalize activity as opposed to the profiling of the word foreigner. I know you're always blunt, that's why you said you do not want to move in circles. But having been here longer than you, it is my advice that in legislation, that's what we do. The other thing, Mr. Chairman, is the definition of foreign interest is not there. When you do the collection for the Attorney General who does not want to meander, when you read the entire bill, you may get a glimpse of what foreign interests they are talking about. But for purposes of criminalizing, there is no definition of what amounts to foreign interest within the, if you read clause 1 and 5 together, which criminalizes. Now, with respect to, and I want to thank, I think the honorable folks, you said Owolweyo. I want to add to the question that he put across when he asked about foreign interest, but also the word sovereignty. You're talking about the protection of sovereignty bill. You also direct Ugandans to protect or promote, I think in clause 5, but you do not tell them in clause 5(3), a person shall not engage in any activity that promotes the interests of a foreigner against interests of Uganda. Now, when you leave ambiguity, you are literally making everybody a potential criminal. Because I don't know, I may not know the interests of those foreigners you're talking about. Supposing their interests rhyme with mine. You're talking about promoting democracy, rule of land, constitutionalism in this country. We may have shared values because this is a global village. So tell me, just be blunt, be audacious and shameless, put across what you want us to do. As subdued Ugandans, we shall oblige. But please do not make them ambiguous to make all of us potentially criminal. Then the activities again, in clause 5(4), clause 5, yes, 4. Again, be clear on which activities you're prohibiting. You don't simply say engage in any activity that promotes the interests of a foreigner. Then you say the person who promotes the interests of a foreigner against the interests of Ugandans commits an offense and is liable, blah, blah. The next comment I have relates to this business of seeking permission from the Minister of Internal Affairs. It has legal, political, and economic ramifications. For the benefit of these young brothers of mine, the ministers who were not there during the days of Idi Amin, even when you sold your land to go and seek treatment abroad, you would go and line up in the minister's office to be permitted to buy foreign exchange. Some people died because the minister would take long to authorize or refuse. In other cases, the minister refused. And when the minister refused, you had no recourse. Today you can say you have recourse, you can go to a court of law where the Attorney General and I are participants, and you know the kind of backlog you have. By the time you get clearance from General Mohoz here, I don't know how much economic interest of Uganda you would have had. I want to implore them painfully because they seem to be hell-bent on having the law go through. why don't you simply legislate on a reporting requirement? We declare. I would have no problem with the word declaring. But if I must seek permission from the minister, assuming I'm a practicing lawyer, someone has paid me 500 million, then for me to require more payment, then I go to the minister. Secondly, I think Honorable Kauma from Uganda mentioned this, the promotion of corruption. Some people are doing business with foreigners. Business, some of which may involve exports of commodities, others services. Then for me to be able to get money, I must go and seek permission from the minister. There is a problem with that. The other question or comment, normally when you are making a legislation that has penal provisions, you also provide for defenses available. When you do not provide for defenses, you make it a strict liability offense for the individual. I don't know whether it is the intention of the Attorney General to make this law a strict liability offense. And of course, I have problems with telling somebody, you go register with the minister or register as a foreign agent. Really, have you taken us to those levels? Or do you see people going to register as agents of foreign interests? I don't see that happening. Then finally, what is government policy? Because we used to say, just write not a booklet, but give us a volume like you give us in your policy framework, so that we know what your policy is all about, and we know how to walk the red thin thread. And then why don't you just be bold enough to declare which countries are hostile, so that we don't deal with them? Previously, I remember in some election where you declared Rwanda a hostile state. I don't know if you have since removed it from the list. Just publish those countries that you consider hostile, so that Ugandans avoid dealing with them, to avoid problems with you for as long as you are still around. There is this thing, this law called the Money Laundering Act, under which I think FIA, the Financial Intelligence Authority, and then the intelligence services have proceeded to block accounts of most of these NGOs, even without going to court. That law is in existence. Why wouldn't the Minister of Internal Affairs simply consider amending that? If you just want to monitor and provide sanctions without causing us these problems of having to fight. For me, as a person who fights to promote national interest and the policy even when I do not know it, I find it very difficult to defend this law with the clauses and even the name. So tell us, what is sovereignty? Which sovereignty you want us to enforce? Because you have made it a crime for me not to promote and protect the sovereignty as in the minds. Very, very finally, just to remind the Attorney General that there is a decision in this country of the Supreme Court that even when I tell a lie about and against the government, I may not have been patriotic, but I don't commit an offense. So are you not empowering whoever will be enforcing this law to use discretion, including arbitrary discretion, and criminalizing all Ugandans by making literally every activity across the borders presumably a criminal activity? I thank you.
specifically, I want to be specific on, because that's what he's saying. If now he sends money above 400 million, is it going to be regarded as a foreigner? Doesn't matter. But that's where we're heading. So what are we trying to cure? Eh? The second one is about the banks. I am aware that Bank of Uganda, each time you are getting money from any foreign person, whatever, they always seek for explanation where these funds are coming from, and you provide that evidence, even if it's more than 400. Is this not going to be a duplication, or for you to run it this way, go and look for the minister, then go and run to the bank? So where are we going to belong in that regard of banks clearance and the issue of Minister of Internal Affairs? And beyond that, I see you here capping that anything beyond 400 million or whatever, you will always keep asking. A practice which I don't see any foreign institution doing it. I've shown you where I'm going to put my money. Why should I keep coming to you because you are saying this permission applies for a period of 12 months? I'm doing my project, whatever it will be, but the banks doesn't do such a practice. Why do we do this capping in this kind of line?
I'm happy to include a definition of foreign interest, but we thought that clause 10 was saying that any function with the aim of promoting foreign policy in Uganda, that has not been adopted as policy by cabinet, but we can define it. We can take it to clause 1 and define it better. Foreign agent being a spy, it could be a spy, it may not be a spy. I don't know, Honorable Keo.
May I seek clarification? Are there policies and activities that the cabinet has approved so that we could know? Because anything that has not been approved and adopted by cabinet would constitute an offense. So we need to know which ones are those that you have
Anything
adopted.
that has not been adopted by a cabinet is not government policy.
So anything, if I act outside that.
Leave that to the committee. If you think it is okay for faith-based organizations to participate in politics in the interest of foreigners, the committee has the power to allow them. Because you see, this act is talking about specific activities which are not for faith-based organization. But if the committee thinks that is perfectly fine for a faith-based organization to participate in politics in the interest of a foreigner, we can exempt them. No, what I'm saying is that these faith-based organizations are already exempt from this law because for them they don't participate in politics. They don't solicit money for the benefit of the foreigners. If they do, well, what we are saying here is, for me, the faith-based organization that I know doesn't do it. So, pardon?
I'm asking whether, so, I mean,
I'll leave that to the chairperson of the committee because, Honorable Lanya, I am here by invitation of the committee. And as I had been advising, I have many things that
we invited you because you sent us a bill.
Yes. So for me, I sent the bill.
Asking why did you send it now?
Like I have so many other bills on the order paper today. Our business didn't stop. This is part of our business. Now, the issue of FDI, colleagues, let us not, and I'm going to say this in a way which I'm looking for the best way to put it across. Uganda is poor. Uganda needs aid. Uganda must get aid in order for it to survive. And therefore we must take aid, whatever the consequences are. Committee colleagues, we need to be careful. We must not receive money for whatever money we need because we are poor. Therefore, we get money to corrupt our morals, determine our destiny. That's what we are saying here. We are not saying we don't want FDI. We are saying let it come. We want foreign direct investment. And it has been coming. But we are saying if it is coming for these purposes in clause 2.2, if it is coming for the purposes of clause 2.2, please don't bring it. Colleagues, Uganda does not need the money at any cost. There must be a point, I was sharing here, if we're allowed to speak vernacular, there were vernacular ways of expressing what you need to do at any cost, that you can get anything at any cost. You may end up selling more than you can give. So yes, this law is not for purposes of stopping FDI. In fact, if there is, pardon? No. I think that's, it may be misunderstood. But what I'm saying is that this law is not about, in fact, if this law has, in your view, the consequence of stopping aid, then we need to rethink it. But if it has the consequence of allowing, if it has the consequence of stopping unwanted aid, then you may want to think about it. So what we are saying here, you need to strike a very neat balance between growth and your security. For example, if we say it's okay for people to recruit, enter into partnership and recruit people, like we say in D, recruit people to promote the interests of a foreigner. For example, we have not had a war here. We've not had a rebel group which has not been supported externally. If we are saying it's okay for us to allow people to recruit for the interests of a foreigner, then that's what the parliament and what we think, but we can find common consensus as a country and say, we are happy to live with it, let's go on with it. So this law is saying, no, if you want to recruit for purposes of supporting a foreign interest, please don't bring it here. That's what the law is saying. So it is excessive powers of the minister, and 2F, I agree this may create an overreach, where any person, institution, or body that the minister may, by statutory instrument, declare to be a foreigner. I think the definition should cover sufficient area, not to allow for things, but that's something that we can look at. I've talked about the countries that you have mentioned, the examples you have used. The examples we have used are for the laws, and you're saying, why don't we have any in Africa? I've not found any in Africa, but I think we need to start being leaders, not being led. Because it has not been done in Africa, then we should not do
General,
it.
I did ask why we go for permission and not simply declaration for purposes of avoiding delays in transactions.
Yeah, I didn't get the clause you are referring to. I saw it here, but I didn't quite get the clause you are referring to.
That's why you did not answer it? Where you talk about the minister giving permission for any additional payment. I think, yes, 15.
15, no?
Yes. Why don't I just proceed with my transaction normally, but with the duty to declare?
I think that you talk about 22, that's what I'm being told.
Yes, then you criminalize.
A person or agent or foreigner shall not directly or indirectly obtain, solicit, or receive any financial support, donation, loan, or other assistance from a foreigner, whether in cash or in kind, in the excess of 20,000 currency points within a period of 12 months without the written approval of the minister. You are saying that?
Because we are avoiding a situation where you literally criminalize transactions. You only criminalize activities. Other than seeking permission, let me transact, I declare, and if I am found not to have declared or even committed a crime, so be it, then you charge me. But the moment you say written permission, you're taking us back to Idi Amin.
Yeah, and not necessarily that everything was bad. I think there was some good even then. So, no, I'm telling you that those people who don't look at the past to try and figure out where they're going, even that experience was an experience that teaches us. Now, I think here what they are saying, if you see when you apply, you make the application for your registration as a foreign agent. And they are saying that in any given year, if you want to get money, you are a foreign agent. You're a foreign agent. You're registered as a foreign agent. You want 400 million, don't even bother going to the minister. You register as a foreign agent, and they know that so-and-so is there as a foreign agent. That person can get 400 million shillings in a year. And for 400 million shillings, they don't need the permission of the minister. But if it is past 400 million, if your plan in that year is worth 10 billion, then go and get written approval. So,
but you do not find it derogatory to refer to somebody as a foreign agent, even as you speak?
Again, that is for the committee. We can come up with a better nomenclature.
No, this is, you see, for me, I speak law. The definition I'm using here is a definition in law. So that is what I'm talking about. And
22 is not restricted for foreign agents.
If that is the clarification you went for purposes of 2.2, that we can do.
That we can.
Because this act, you see, and I think for me it's a drafting thing, because the application of this act, the application of this act in section 2, everything you read in this act should be read to apply to only this. Because this is the application question. So you cannot talk about anything else other than this act only applies to this. So this is the application. So you can clarify it and make it a better English and repeat it and say, as stated as per the application of the law. But you see, this act applies to a person who is an agent of a foreigner. This act. So don't ask me, who has no dealings with a foreigner, under this act. I have no business.
Exactly. Now, 22 is saying a person.
If that is the clarification you went for purposes of 2.2, that we can do.
That we can.
Because this act, you see, and I think for me it's a drafting thing, because the application of this act, the application of this act in section 2, everything you read in this act should be read to apply to only this. Because this is the application question. So you cannot talk about anything else other than this act only applies to this. So this is the application. So you can clarify it and make it a better English and repeat it and say, as stated as per the application of the law. But you see, this act applies to a person who is an agent of a foreigner. This act. So don't ask me, who has no dealings with a foreigner, under this act. I have no business.
Exactly. Now, 22 is saying a person under 2.2.
Under 2.2, it does not relate to my grandmother in the village who has no dealings with a foreigner. You cannot come.
So your grandmother can solicit from a foreigner.
My grandmother can solicit from a foreigner so long as they are not doing
activities
under 2.2.
Okay. I think it's. Thank you. Go on. Are you concluding?
No, the minister's powers, because you see, if you say that you should allow people to receive $1 billion, I don't know, I'm looking for words to use in English, but I can't find them. But I may be more expressive in Uganda. In Uganda, we're saying, you know, you're saying that you may try to cover yourself. Okay, having spent the whole night uncovered, at about 6 in the morning, you cover yourself. You have not served any useful purpose. So if you allow all the money to be spent, and then the problem has already been done.
Attorney General,
so reporting tomorrow.
The current practice is, even when I'm receiving people, you do not restrict. Because first of all, at the level of soliciting,
but I've answered the question, Honorable Segona. I've told you my understanding of it. Okay. You have said you'd rather let whatever amount and they report then after.
Actually,
so we are saying, if they are receiving money for purpose of recruiting a rebel outfit,
then they declare after.
Then they declare after the rebel outfit has been recruited. Well,
fate accomplished.
So we are saying that the declaration after Yeah.
No. Actually, contrary to what you think, and by the way, I should be understood being the Anti-Money Laundering Act, which requires the banks, before they even allow this money onto my account, I'm required to explain
Declare
and
source.
even prove, declare the source. And someone has been bounced back, which I also find outrageous. If it has come, why do we bounce it back? Let the government take over, take the money. But my question is, one, delaying transactions. Two, is where the minister does not even have timelines.
That is now a function of law. We can...
And further bureaucratization of what we want to achieve. There is the aspect of the checks before the fact, which the Attorney General alluded to, and not after, when things have gone bad. But also the bigger worry of the committee was, what if the minister abuses his power? So what better way, if not the minister? I think that we should leave to the committee. If you think the minister is overweight with this responsibility, which is going to be frequent, then what better way can it be addressed?
But also looking, take her husband for cancer treatment out of this country. She went there 3 times and she would be told the minister is not in good mood. The 4th time, she enters, the minister got the papers and threw them in a dustbin without looking at them. I want to avoid creating a minister of that kind. Why do you insist?
What's your proposal?
My proposal is, first, let the money come. It will not be released because the practice is they will not allow it into your account. They will
Banks
not allow
will
it.
not release.
They will not. We can make a law to that effect. That's number one. Number two, we must also cap the minister's
Powers.
power and exercise of discretion. Within how long?
Yes,
Number
that's
three,
now what we is.
when you're talking about solicitation, at the time of solicitation, I actually do not know whether I will get this money. Because NGOs in this country write proposals. You're simply writing a proposal. You're now telling an NGO that it cannot even write a proposal. You understand? Because the determination of what will be foreign interest will be a decision of one person who is enforcing the law. Did you write this? In my interpretation, this was promoting a foreign interest. Anyway, I wanted to throw this to the Attorney General from a technical angle before we write our report, to tell us what he thinks about those views, because for me, I'm persuaded to think that you're bringing this law in bad faith. Convince me that you're acting in good faith, and then I'll give you a good law.
No, I advise to let money come in and then deal with it after. But that I leave to you. That's what we thought. We thought it was not wise. We thought it was important to curtail. But what I need to tell you is that this law is not replacing other laws. This law is creating a category of persons to be addressed under this law. For me, what you want to do, I don't know how far more you would put the application of the law. Maybe we should put another clause 3, a clause 4, and say, for further avoidance of doubt. Because we have put for avoidance of doubt.
For further avoidance.
For further avoidance of doubt. And additional avoidance of doubt. The people who are not agents or foreigners will not be required to go to the minister. So,
and do you know why there is doubt to be avoided? It's because you cannot be trusted.
Okay, I think we are making headway. Honorable,
at least
I'll give you a chance, Honorable.
My Honorable Anya is saying the law is targeting very few people. Of course, the 50 million Ugandans are not all criminals. For example, we have the law on murder. It's not targeting all the 50
including Golanya himself.
Yeah.
He's not.
Like for you, we are not targeting you. But if you happen to do these things, but you see, the law is supposed to deal with a particular problem. And the problem is not for everyone. So not all Ugandans do this. And actually, the law also may deter others from doing it. So yes, it is targeting a few people, and it will